Hi, this is Attorney Feng, immigration lawyer from New York City. Today we're going to talk about our trick to always use level 1 wage for your H-1B extension. So after you work under H-1B for 3 years, when you do H-1B extension, you already have 3 years experience. Do you have to use level 2 wage? Today we're going to teach you a trick. Always keep level 1 wage, no matter how many years of working experience you have. Why do we have to use level 1 wage? That's because 80% of H-1B sponsors are small business. They could not afford level 2, level 3, or even level 4 wage. If they could not afford a high wage, you're going to lose your job. You're going to lose your status. You may have to leave the US. So keep a lower wage is the key to keep your job. There are 4 level wages assigned to each occupation by Department of Labor. So during Trump administration, even the first year H-1B, USCIS has challenged you have to use level 2 wage in order to be considered this position as H-1B specialty occupation. We successfully rebutted that challenge because the standard to determine whether this position is H-1B specialty occupation is not about wage level at all. It is about the job duty, whether the job duty requires bachelor degree to perform. If it is, even you are a level 1 wage, this position is specialty occupation. Use the same methodology when you extend your H-1B. Seems like you have 3 years experience. When USCIS asks you, you should use level 2 wage because you are more experienced. That sounds very reasonable, but it is not required by law. Remember that. We use the same methodology because your H-1B position requests bachelor degree to perform the job duty. If it still only requests the bachelor degree, it does not request any working experience. It is still an entry-level position. Even you are overqualified. The law does not prevent your employer to hire an overqualified employee for entry-level position. So no matter how many years of working experience you have, you can still use level 1 wage for your H-1B extension. Remember that. When USCIS challenge you, always go back to read the regulation. If the law has said that, if the regulation has such language, if not, we figure out a way to rebuttal that challenge. So no matter how many H-1B extension you have, you can always keep the required prevailing wage low so your employer will have less burden in terms of paying your salary, so you could keep your H-1B status. If you think our information is helpful, give us a thumbs up, subscribe, and share. Thank you.